and welcome to a newsflash episode of Unpacking the Case, the podcast by Davitt Jones Bold, the real estate law specialists. As always, I'm joined by our head of legal training, Richard Snape. Welcome back to Unpacking the Case. Today we're looking at one of the biggest shake-ups in the real estate market in years, the Renters' Rights Act. Since the legislation came into force, the property sector has been flooded with questions, and in some cases, genuine concern about how these reforms will work in reality. At our recent webinar, there were questions on everything from worries about court capacity and possession delays, through to uncertainty around fixed-term tenancies, rent review mechanisms, pets and mixed-use buildings. In this episode, we're doing a full Q&A special using real questions being asked by our audience of property professionals. Hello, Richard.
Hello, Lizzie. It's been a long time again.
We are battling against technology today. It seems to be throwing everything it can at us to stop us from recording this podcast.
But we won't be silenced. The public need to know about the Renters' Rights Act.
Exactly. We certainly won't be silenced on the Renters' Rights Act. We had a webinar earlier in the week, which was extremely popular, and we had over 200 questions. So we are back.
Over 500,000 registrants.
We did. There was a lot of people listening to what you had to say about the Renters' Rights Act. So luckily, you've got plenty to say about it. So I'm going to ask a few of the questions we didn't get to. The first one, a bit more of an overall sort of general question about, do you think there are suitable financial provisions for the courts to handle all the matters relating to this new act?
No, that's that one. But I will tell you, the government's basically saying late last year they gave local authorities, not the courts, but local authorities, £18 million. And then in April, they gave them another 41.12 million because they're supposed to be the body to enforce. I'll come back to the courts in a minute. That's currently there are 317 local authorities in England, which Lizzie is now going to tell you their names. But that's £189,000 per authority to do all the enforcement. And that's sort of, full stop, not on every year or anything, and it doesn't seem to be enough. Some local authorities, about 2/3 of them, have not prosecuted anybody for breaches. Far fewer breaches in the last 3 years. But in terms of the courts, the government's saying they're going to give the courts another 50 million, the civil courts. It's 50 million to over a period of time to digitalise the court system. That is not just for the Renters' Rights Act, that is across the board for all civil court proceedings. And it's a bit of a pittance. They were always slow with bringing, hearing possession proceedings, but they have really fallen very, very slow post-lockdown, where for much of 2020, nothing was happening in terms of possession. So it's a drop in the ocean. I think it's going to cause problems. I also think it's going to cause major problems in the tribunal system when all the tenants start to question the landlord's rent increases, and I can foresee major delays there, major. And the new lease can't kick in until the tribunal's made its decision, and it won't be backdated anymore. So yeah, I think there's huge issues. So Geoffrey Voss, the current Master of the Rolls, has mentioned some of the problems looming because of this, but yeah.
Okay, thank you for that. So we're going to talk a bit more now about fixed terms, notices and possession. And the first question we're being asked is, if a fixed term tenancy was signed before the 1st of May 2026, does the fixed term element fall away or stay until expiry?
No, it falls away on May the 1st, 2026. It might have been a fixed term tenancy on April the 30th. It's now an assured periodic tenancy. It is retrospective completely.
Okay, next question is, can a tenant now give notice earlier than a landlord who already served notice before the Act came into force?
It seems so. I mean, basically, under the Housing Act, which is the Renters' Rights Act, or these parts of the Renters' Rights Act just amend the 88 Housing Act. But a landlord can only terminate a lease under Section 5 of the Housing Act by getting a court order, which is then executed, getting the bailiffs around if needs to be. That's the only way a landlord can terminate a lease, or with one or two exceptions, primarily about immigration status and whether you've got a right to rent. And that's the reason. It's the reason why in the past, before they put a duration limit of 7 years post December the 27th, 2025, or before that date, 21 years. It was a reason the problem with long leases potentially being short holds, because you can't effect forfeiture of short hold tenancy. It doesn't fall within Section 5. But it seems that the tenant, if they don't want to be there, for the landlord's notice period, they want to move elsewhere, then they can, as of May the 1st, at any time give 2 months' notice. So it seems to be the case, yeah. They'd have to be a bit careful if they haven't got somewhere else to move to, because they'll definitely be intentionally homeless for homelessness legislation.
Thank you very much. Next question. Could tenants effectively stay for 16 months because of the first year restriction plus the 4-month notice period?
Yeah, this is for ground 1A and ground 1. Where your landlord wants possession as their principal home for themselves, their spouse, civil partner, cohabitant, or a family member of such people. Or ground 1A, when you intend to sell the property, you have to serve 4 months' notice, and you can't do so within the first year of the tenancy agreement, but you can serve the 4 months within the first year. So you don't have to wait. You can, after 7, 8 months, you could serve notice terminating, on the year. Having said that, if the tenants refuse to go, and again, if they decide to go, they might just be found to be intentionally homeless by the local housing authority. You'll have to go to court, and you'll then have to get the bailiffs in if they still refuse to go, and that takes a long, long time. In London, a very long time. It takes 8 months to get the bailiffs around in London. The courts, I did see figures that suggest about 42 weeks in London, the national average being lower.
A couple more questions on ground 1. The next one is, if a landlord uses ground 1 to move back in, how long do they genuinely need to stay before reletting?
It's a difficult one, because there's not been much on it, because in the past, the various grounds haven't really been used that much, because everything's been insured short hold, and you just serve the 2 months' notice. It's where the landlord or their family intend to live there, a genuine intention. So it's not inconceivable that you successfully use ground 1 and then decide to sell the property at a later stage. But it's a question of, whether you intended or not. Or if you intended to do that from ground 1, it's not going to help. Do you remember we did a podcast on, it's nothing to do with this, but just generally on the 54 Act, actually, but there was a case called Patel and Kellis on the 54 Act where the landlord intended to occupy for their own purposes, but admitted that after 2 years he intended to sort of sell the whole place, and he failed. If you got an intention to sell at the very beginning, I suspect, that you're not going to be able to use ground 1.
Another one on ground 1 is, what happens if a landlord regains possession to sell but the buyer pulls out?
If the landlord genuinely intended to sell the property and loses their purchaser, then there's nothing stopping them continuing with ground 1 and intending to sell to somebody else. But they're going to have an intention. I think there's an analogy there. I've seen sort of an article on it that, how do you decide whether there's a genuine intention? It's a bit like the grounds F and G of the landlord intended Act 1954. And a case that's always quoted, although it's not about the 54 Act, Cunliffe and Government. I mentioned it in the webinar, actually. It's got to be out of the zone of contemplation and into the valley of decision. The one problem if the buyer pulls out is if you've used ground 1, you won't be able to relet for the 4-month notice period plus the year that follows. And that's on a short lease of 21 or less years, including Airbnbs or a license you won't be able to create. So if the buyer pulls out, you're going to have potentially a vacant property for a significant time period.
Okay, thank you. Moving on, talking about CPI and RPI linked rent increases, can landlords still use them after the Act?
No. If you've got a rent review clause, this part is going to be retrospective, but if you've got a rent review clause as soon as on May the 1st, even if the rent review was in a lease prior to May the 1st, then it can't be used. And RPI and consumer prices index are basically rent review clauses. So no, it's got to be the mechanism under the Section 1340 of the 88 Act.
And if a tenant challenges a rent increase but loses at tribunal, is there any penalty or cost consequence?
They have to, whether they win or lose, they have to pay a fee of £47. They were talking up originally, there were suggestions that it'd be 100, but it was reduced to £47. Considering the fact that it's going to take ages, you would imagine, for the tribunals to hear, and the tenants have to be told in information sheets or in a written statement of their rights to question the rent. Lots of tenants are going to be questioning the rent, and £47, because when the final decision is made, it can't be backdated. It can actually be extended for a further 2 months if there's hardship for the tenant. But lots of tenants are going to make the applications, and £47 will be money well spent.
Okie dokie. And will the tribunal assess market rent at the date of the notice or the hearing?
It's the market rent at the beginning of the new period specified in the landlord's Form 4A notice, which has to be at least 2 months.
Okie dokie. And the next question, there was a lot of talk in the webinar about pets, lots of questions about pets. And this question is asking, can landlords realistically refuse pets in leasehold flats where superior leases prohibit animals?
If there's a superior lease that prohibits animals, then the superior lease prevails, so the landlord can refuse.
And another
if it doesn't prohibit, then the landlord's supposed to ask the superior landlord's consent if it's subject to reasonableness or whatever.
And can landlords limit the number of pets?
Well, that depends on what's reasonable. Yeah. If you've got 10,000 dogs, then that's probably reasonable to limit the number. But it depends on the nature of the premises and so on.
And who makes that call as to what is reasonable, though?
Well, at the end of the day, eventually you can get to a court order, so the court will make a decision for specific performance, but you must really love your pet to do that. When the ombudsman, the redress scheme comes in, but that's not going to be probably until 12 to 18 months after the private sector database, which they're talking about late this year, early next, then the ombudsman could decide it, but that's a couple of years at least away.
Okay, thank you. And what happens with mixed use buildings, for example, a commercial lease with a flat above where vacant possession is needed at lease expiry?
I'm not sure this is about pets, but
John.
if it's mixed business residential, if it's on the same lease, it's a commercial premises, unless you're just taking work home with you or you're in breach of the user covenants. A case called Cheryl Investment Saldana, 1978. It comes within the unless you've excluded the 54 Act, it comes within the 54 Landlord and Tenant Act. So you have to serve Section 25 notices, and so it's business tenancy. You can create something called a home business tenancy under this Small Business Enterprise and Employment Act, which came into force on October the 1st, 2015, and still retain the residential regime. It's got to be something, a type of business can be reasonably out from home, and doesn't include having a pub, unfortunately. And the lease has either got to allow that business user, or it's got to allow subject to consents. But people don't create them because people have not heard about them. With that proviso, it's a business tenancy. Even if you work home with, even if you're sort of seeing clients at home, and so it's got a lot of other implications like change of use for planning and paying business rates and likes.
Final question. Could landlords simply advertise unrealistically high rents to get around the ban on rental bidding wars?
When they advertise the property for rent, they have to state what the maximum rent they can accept is, and even if the tenants want to pay more, they can't accept it. And inevitably, that's going to potentially push rents up because they'll put as high a rent as they think they can get. Do ask the other questions. They wouldn't take long.
Yeah. Some quick fire questions, or hopefully quick fire questions to finish. Are student lets exempt?
If it's student lets from a specified higher education establishment, basically halls of residence, they're exempt as of May the 1st, but not retrospectively. If it's purpose-built student accommodation in the private sector, it's been purpose-built, for students. or mainly for students. It's got to have at least 15 bed spaces in it. Then, as long as the landlord has signed up to a code of practice, Unipol or ANUK, then they'll also be exempt. But otherwise, outside those, student accommodation just in the normal private sector is not exempt then.
And does the Act apply to lodgers?
Lodgers are probably licensees if they're genuine licensed lodgers. And therefore, the Act only applies to leases, even if they weren't licensees. If you're sharing accommodation with the landlord, like, bedroom or kitchen or bedroom, well, probably that's a good way of reducing your rent if you're sharing the bedroom with him. But a bathroom is what I meant. But then sharing with the landlord would be exempted. It's going to be a sort of, you've got to have exclusive possession. If they've got a resident landlord, and this is not a lodger, but if there's a resident landlord even in the same building, but your flat, is self-contained, it's an exclusion as well.
And what about Airbnb properties? Are they caught?
Airbnb would be equivalent of holiday lets. They're probably business tenancies anyway. And so, not residential, it's not your only principal home. And they are the equivalent of holiday lets, and holiday lets are specifically exempted.
And we've talked about pets, but what about smoking and vaping? Can they ban that?
No, pets smoking and vaping or
That
people,
probably isn't advisable, but I meant humans.
there's nothing stopping you banning smoking or vaping. No.
And I think we mentioned this during the webinar itself, but the Homes for Ukraine scheme, does that fall outside of the
I
regime?
think they don't pay a rent, and I think they're licensees basically, so they're outside the regime as well. It's a license agreement really. It's got to be a lease to be within the provisions. In England and Wales, occupation contracts can be licenses, but certainly in England.
And last but not least, do existing ASTs now automatically become periodic tenancies?
Yeah, on May the 1st, they all became periodic assured periodic tenancies. Even if they're assured short hold the day beforehand, there are no periodic tenancies assured, and there's no short hold notice available as of May the 1st. There was beforehand.
And there we go. All done.
Well,
thank you very much.
Mm-hmm. Well, thank you, Lizzie.
Thanks very much, Richard. Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.